Namaskar, Dilip Singh Advocate. You are welcome to my channel Journey of Constitution of India. Let me share you a very interesting story. It was 28th of August 1966. A dinner was hosted to celebrate the centenary of Bombay Bar Association, and the main speaker Nani Palkiwala started with his story. He said once a rich old man asked his lawyer to prepare his will, and he paid a very handsome fee. After a few days, when the lawyer prepared the will and handed over to the old man, he read the will and he started shouting, "What you have done? You have given the entire my properties to the other persons, nothing left for me." And Nani Palkiwala said this story on the background that he wanted to say that all these speakers who had stated before him, who has spoken before him, has already spoken everything about the Bombay Bar Association's achievement and the history of the last 100 years. So he was left with nothing to speak. And the similar is my condition when I am making video on the laws of arrest and bail. The topic of arrest or bail are so thoroughly discussed in colleges and in courts, so that every lawyer or every student of law has enough information on laws and legalities of provisions of bail. But there is something which I find worth discussing you. On 11th September 2015, Government of India asked Law Commissions of India to examine the desirability of having a separate bail act, keeping in view of the similar provisions in United Kingdom and other countries. Let me tell you here that in United Kingdom there is an act, a specific act known as the British Bails Act. So the purpose of this letter was to ask the law commissions to go through that and prepare something in that, a separate Bails Act. Let me tell you two important facts about the Law Commission of India. The first is that it is neither a statutory body nor a constitutional body. It is in fact established with an executive order. The second important fact which I would like to share with that, the such commission was established for the first time in 1834 under the Charter Act of 1833. The commission was under the chairmanship of Lord Macaulay, which recommended codification of the Indian Penal Code and Criminal Procedure Code. Now coming to the present situation, Justice B.S. Chauhan, a retired judge of Supreme Court, was the chairman of Law Commission, and he worked on the assignment of preparing a separate Bails Act. But on 18th of October 2016, almost after more than 1 year, government changed its plan and decided to drop the idea of making a separate stand-alone act as on the pattern of British Bails Act, and the Law Commission was asked to work on the changes in the provisions of Criminal Procedure Code to get the desired result, which earlier it was to be achieved through a separate act. Law Commission submitted its work as the report number 268 on bail reforms. The title of report is Amendment to Criminal Procedure Code 1973 Provisions Relating Bail. And this report was to take the form of the Code of Criminal Procedure Amendment Bill 2017. So now we start to the laws related to bail. So the first question arises, what is bail and what is the purpose of bail? Interestingly, bail is not defined anywhere in the Criminal Procedure Code, and in the simple term, the word bail is a surety. In fact, bail is a tool to ensure the appearance of the accused of an offence during trial and to ensure that he does not tamper with the evidence in any manner. So another question is, what are the provisions which govern the bail and why it is found inadequate by the government? The provisions relating to grant of bail are enshrined in Chapter 33 of the Criminal Procedure Code, starting from the Section 436 of CRPC to 450 of the CRPC. Here, it is pertinent and it is relevant to say that the offences is classified or categorized in two categories, that is cognizable and non-cognizable, and even Bails are categorized into categories: bailable and non-bailable offences. The law related to arrest with or without warrant and the right of persons who are arrested are contained in section 41 to section 16 of CRPC. In 154th report of Law Commission, the entire provisions related to arrest was reviewed by the Law Commission and supported the conclusion which was reached by third report in the National Police Commission, that 60% of the arrests in India are unnecessary, and such arrests accounted for 42.3% of the jail expenditure. So these were the guidelines which forced the government to think in this change in bail provisions. The major changes was introduced after in 1973. The major changes in these all provisions were introduced in 1973 on the recommendation of 41st report of 1969 by the Law Commission. It tried to strike a fine balance between the freedom of person and the interest of social order. But I can say that the things did not work well. This is my opinion, and I am supported by the data of National Crime Record Bureau given in its report in 2015, that 67% of the prison population in India are under trial, and a majority of under trials, that is 70.6%, are illiterate and semi-illiterate. So this conclusion can be derived from this data that these present bail provisions are not suitable for the poor and the illiterate. Why India could not do better on the aspect of speedy trial? Because if the under trial prisoners are so huge, it means the trial taking much time than it should have been, it ought to have been. So why no speedy trial? As an advocate, I feel that the speedy trial is a big issue in the Indian court, and one of the reason for delay in the trial is the absence of proper and adequate judicial infrastructure. The question arises: can the lack of resources be a justifying ground for undue detention of under trials? Of course, you all will agree with me that the answer is big no. State cannot do it. And even Supreme Court has categorically found in the case of P. Ramachandra Rao versus State of Karnataka, AIR 2002, Supreme Court 1856. It held that paucity of funds or resources is no defense of denial of speedy trial, of right of speedy trial emanating from Article 19, 21, 14 and the directive principles of Article 39A. So the right of speedy trial is related with the Article 21 also. No doubt the state has the first and foremost duty of controlling the crime and must not be at the cost of constitutional human rights. In this backdrop, we need the changes in criminal justice dispensation or CRPC. We need a paradigm shift from the approach which we are having till now. So, do you remember that in 2008 the question was taken very seriously, and particularly in the case of Joginder Kumar case, and the Supreme Court held that there are certain guidelines to be required to be given in the case of arrestment, and these guidelines were given statutory shape. The guidelines given by the Supreme Court in Joginder Kumar case was given statutory shape by the amendment in CRPC in 2008, and particularly section 41 of CRPC was amended to limit the power of arrest for cognizable offences for which the punishment is 7 years or less, and it was specifically directed that the police officer who wants to arrest any person must give the reason of arrest. It should not be the automatic arrest on the registration of FIR of a cognizable offence. So police officer had given a special duty to record that. It was important. I would mention that there is a very important judgment then came after in 2008 in 2014, 2014 in the name of Arnesh Kumar versus State of Bihar, and where again this all aspects were re-examined by the Supreme Court and given certain guidelines in 2014. Arrest must not be automatic, but with a reason for arrest by the police officer, and it is incumbent on the police officer to write down the details of the reasons why arrest is necessary in that particular case. The police officer has to prepare a checklist to be forwarded to the magistrate along with the reasons and the materials that necessitated the arrest. Only the recording of satisfaction of magistrate may authorize detention. Even after arrest, a special duty was put on the magistrate that magistrate has to record the satisfaction for further detention. Even magistrate duty was taken to task here in this Arnesh Kumar case. If detention is authorized without recording reason by the judicial magistrate, the concerned magistrate may be liable to face the departmental action. The magistrate must apply his mind while authorizing detention beyond 24 hours as provided under section 167 of CRPC. Another important development in the is to inform that accused has to be informed about the arrest in vernacular language, and he is entitled for the legal aid. And later on, this statutory provision was added for the legal aid to the accused persons who cannot afford the legal help. The most important steps after arrest is remand, where a judicial officer takes stock of the decision taken by the police officer. So remand is something between arrest and prison. What are the remand laws and how it can be made more effective so that any wrong committed by a police officer cannot perpetuate further? I'd like to say that section 56, 57, 167 and 309 of CRPC deal with the procedure related to the grant of remand by a judicial officer. The difference between judicial and police custody is not simply the custodian. The very important distinction between this police custody and judicial custody is that under police custody, interrogation by the police is permitted, whereas under judicial custody, no interrogation is permitted except in exceptional circumstances with the permission of the court. Legislative authority for detention of person in prison for a suspected offence is provided under section 167 of CRPC and 309 of CRPC. The code, however, makes it clear that before taking any cognizance, 167 is applicable, and after taking the cognizance, 309 is applicable. So these two provisions of detention are different from each other. The Law Commission discussed each and every stages from arrest to remand to prison to bail. These all stages in detail. So, and it needs to go through the each stages recommendations with reasoning, and that will take time because that is 125 pages recommendation of the Law Commission. So I'll make the next video in which I'll take the different recommendations made by it. Here we halt in this journey, and thank you very much for watching this video. Please share this video with your friends so that it can get exposure and I can get comments from the viewers so that I can improve it. Thank you very much. Please share your views in the comment sections of the video. One special request to you: kindly wish me good luck by subscribing to my channel. Thank you very much. Namaskar.